Hello everyone, welcome to Cashcroft TV. My name is Kalen Ashcroft. Thanks for watching this video on Guide to Legal History and Historians, where we will be going through chapter by chapter the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins. This video we will be going through the two chapters, Legal Formalism and Sociological Jurisprudence and the Spirit of Common Law, by Michael Lobban and Noga Morag-Levine, respectively. These are chapters 23 and chapter 4 of the Oxford Handbook of Legal History in part 3. However, I think this video stands very well on its own, so if you have not seen any of the others, this will work just fine and in fact be, I think, meritorious in its own right. And this video will be done in the style of Plutarch's Lives, so I do take an individual or a people perspective, so I will have biographies of each of these two authors at the start of each chapter, and then as well at the end of covering both chapters we will have a comparison of the two. I think not because these two are, although the two chapters do cover opposing forces in the legal history community, they're not directly opposed to each other as terms of scholars, but I think this is the best way to learn about individuals and as well their respective scholarship. So, without further ado, we will begin with the chapter on legal formalism by Michael Lobban. So, in terms of a brief biography about Professor Michael Lobban, he was born in 1962, so this is his 60th year if you're watching this in 2022, the year this is recorded, and he is a fellow of the British Academy, and he has been since 2015, when in his 52nd year, which is the leading academic distinction in the humanities and social sciences in the United Kingdom. Furthermore, he is a professor of legal history at the London School of Economics, and he has been in this position since 2013 in his 51st year. As well, he was previously a professor of legal history at the Queen Mary University of London from 2003 to 2013, so for 10 years there, starting in 2003. And furthermore, he was born in Cape Town, where he received his Bachelor of Arts in 1984, when he was 22 years old, and then he received his Bachelor of Arts at the Corpus Christi College of Cambridge, and he received his doctorate there in 1988 when he was 26, in his 26th year. His PhD, or his doctoral thesis, was The Development of Common Law Theory, English Jurisprudence, circa 1760 to circa 1830. He did a junior lectureship at the University of Witwatersrand at Johannesburg in South Africa in 1988 after completing his doctoral degree, and he was elected a junior research fellowship at St. John's College, Oxford in 1988 soon after, and in 1991, in his 29th year, he was appointed to the leadership at the Durham University, or lectureship, pardon me, at Durham University in Durham, England. And he was promoted to a readership 4 years later in 1995 in his 33rd year, and in 1997 in his 35th year he joined Brunel University London in Uxbridge as a reader. In 2000, in his 38th year, he was selected for a readership at Queen Mary University of London, and he became a professor there in 2005. He is, according to his British Academy profile, he specializes in the history of 18th and 19th century English law and lawyers, with a special focus on the relationship between doctrine, institutions, and legal and political thought. He's also the secretary of the Selden Society, which I discussed previously is a learned society and a registered charity concerned with the study of English legal history. He has some books as well, such as The Imperial Incarceration, Detention Without Trial in the Making of British Colonial Africa, published by the Cambridge University Press in 2021, A History of Philosophy of Law in the Common Law World, 1600 to 1900, published by Springer in 2007, White Man's Justice, South African Political Trials in the Black Consciousness Era, published by the Oxford University Press in 1996, and The Common Law and English Jurisprudence, 1760 to 1850, published by Clarendon Press in 1991. So regarding his chapter, so his chapter is in part 3 of the textbook, the Oxford Handbook of Legal History, titled Part 3 is Perspectives, Legal History in Modern Legal Thought, and his chapter is number 23, Legal Formalism. So he opens up by saying, legal formalism is usually taken to refer to the period in American legal thought between the 1860s and 1920s, when a new generation of postbellum treatise writers and legal academics sought underlying principles of common law areas and put them in rational order. If you're not familiar with the word postbellum, that means post-war as well. So that's an important context to take into account. It's also considered classical legal thought, or a Weltanschauung, which is a world theory with the judiciary, and it's also associated with laissez-faire economics and individualism. That is legal formalism. In contemporary jurisprudence, formalism is considered a specific approach to adjudication and constitutional interpretation. There's both defenders and criticisms of formalism. However, the term legal formalism itself was not actually used in the 1860s to 1920s, and it was actually coined by anti-formalists known as realists, who treated law as a system of abstract and who believed that legal formalism was treated as a form of abstract concepts applied to by deduction to the facts by a particular cause. For a particular case, realism would be for cause. And therefore, legal formalism, the critics, realists say, is blind to policy choices and social purposes that had shaped the content of law. And furthermore, it privileged private law and marginalized public law. That is legal formalism again. Roscoe Pone's famous critique said it's a mechanical form of jurisprudence whose rules and doctrines are judged by their conformity to a supposed science and not by the results to which they lead. And it's also, this time is also considered the Gilded Age of law. There are a range of opinions within the it's also considered the orthodox legal thought in this era, and it's which is even larger than the realist character might have suggested, whereas many jurists developed theories in which moral history and historical investigation did play a key role. So it's not as black and white as the realists might say. Not all legal formalists neglected social issues or political issues. Some clearly did. And this chapter will show the formalists were not simply narrow-minded logicians who imbibed the learning of analytical jurisprudence but rather scholars bred in common law tradition who sought to make sense of a new age by incorporating methods of the latest jurisprudence learnings, both historical and analytical. So, as I said, it's not all black and white. They're kind of incorporating a new analytical approach while also not completely turning away or not completely neglecting the political and social implications all the time, or for all individuals. So that was the introduction. So moving to part 1, which is called Locus Classicus, Locus Classicus is generally agreed of the critics' definition of formalism is defined often by Oliver Wendell Holmes' review of Christopher Columbus Langdell's Summary of the Law of Contracts, where he considered Langdell the greatest living theologian, and he was entirely interested in formal connection of things or logic, as distinguished from the feelings which made the content of logic, which eventually shaped the substance of the law. So we'll talk Langdell is probably the most key figure in legal formalism at the inception, but in terms of defining legal formalism, it was Oliver Wendell Holmes in commentating upon Langdell, who was a dean of Harvard Law School. So Langdell, he revolutionized Harvard as the dean, teaching by incorporating the case method, which is now the most commonly way of teaching common law. And also he was the progenitor of a tradition of legal scholars devoted to taxonomy of legal concepts. And law was considered as a science and consists of certain principles and doctrines that need to be mastered to be able to apply them with constant facility and certainty to the ever-changing scheme of human affairs. So he believed case law with a certain doctrine was necessary, and formerly it was taught by apprenticeship. And it's interesting also to note that in Harvard Business School also uses the case method, so it's also expanded into other fields as well. And therefore, legal formalism can be seen in line with doctrinalism, in my estimation. Therefore, Langdell also assembled a group of scholars, including James Barr Ames and William Keener, as well as John Chipman Gray, Joseph A. Beale, and Samuel Williston, who developed the case method and further doctrinal work. For example, Gray, there was a rule in his rule against perpetuities from case law. He backed up the Middle Ages. He said, if the answer to a problem does not square with the multiplication table, one may call it wrong, although it be the work of Sir Isaac Newton. And so if a decision conflicts with the rule against perpetuities, one may call it wrong, however learned and able the court that pronounced it. So there's something to be, this quote, what's really revealing is that there is certain rules that need to be agreed upon within the legal community. And even if it's a top legal scholar who proposes a new interpretation, if it does not align with the previous interpretations or the correct interpretations, then regardless of their reputation, it's not valid. Furthermore, Keenan said there's a mechanical misclassification of legal topics is not only unscientific and therefore theoretically wrong, but also destructive to clear thinking and therefore a vicious practice. So they're really a certain doctrine of a way of doing things. The realist said this legal fundamentalism of formalism must clearly encapsulated in Beale's treatise on the conflict of laws, as law is not a mere collection of arbitrary rules, but a body of scientific principle, a general body of law, and that is ius versus lex, or right versus lex. Right. Ius is right, and lex is law, and therefore a branch of practical philosophy. But this is a way the realists are defining it, but in all intents and purposes, that is the agreed upon interpretation of legal formalism. Therefore, they were seeking a purity of doctrine that could be lost through wrong decisions. So things had to be done in a correct way. Therefore, Langdellian formalism did not amount to a theory of law beyond occasional statements of methods in prefaces, however. So, although they're defining this sort of doctrine and this legal formalism, they didn't really specifically define it, except for kind of mentioning it in prefaces, but without using the word itself, legal formalism. It was furthermore not out of step with some formalists, realists inferred theory, and they were skeptical about the autonomy of the legal doctrine. For example, in Holmes's aphorism in the review of Langdell, life of law has not been logic, it has been experience. So Holmes, although he was the one to likely define realism, or legal formalism, is likely considered a realist, and he actually criticized in many ways that work of Langdell, saying that law has not been logic, it has been experience. So there's a social or political element as well. But however, this is not completely out of step with some formalists. For example, Gray said many courts make ex post facto laws, and courts may decide a novel case differently from neighboring jurists. So there is kind of a flexibility to social pressures. And therefore, he said, if Newton were wrong, the universe would remain unchanged. But if judges go awry, their bad decisions remain. So once again, referencing Newton, but also showing the importance of being dynamic. Beale also argued even there's a need to study law with a view to its readjustment and reform. So they're not absolute legal formalists, or they're not completely unwavering. Furthermore, for example, Bigelow in his highly formalist Law of Torts, with chapters on specific torts beginning with a statement of duty. So a statement of duty is this legal formalism at the prefaces often mentioned, where he said the limitations of logic in the presence of social change and the danger of it should be plainly taught. So even these so-called legal formalists do see the caveat and the risks of being perhaps too formal. And furthermore, it's seen as a scientific school of law should study all sources when the law is to be declared, not only procedures and historical doctrines, but also direct and indirect sub-legal groups, such as business and pursuit generally, and other less tangible influences, so a sum total. Furthermore, they have to take into account political, economic, and psychological influences. And the books do not contain, either in development or in germ, all the law. So many of these, once again, these legal formalists are perhaps not so clear-cut as some realists might define them. Moving to section 2, doctrinal writings followed in the footsteps of several generations of legal scholars, starting with Blackstone's Commentaries. Simon Greenleaf was, who was also Langdell's predecessors as dean of Harvard Law School. He said the adjudicated cases are, to the philosophical student of law, are what facts are to the student of natural sciences. And he said this in 1838. So these cases and these case books that Langdell introduced are sort of becoming the rules and the facts of history. And there's once sort of, as we saw in the chapter, or many chapters, speaking of doctrinalism and common law, there's sort of not too much flexibility once a case has been decided, and once the case book is kind of created and set in stone, there aren't, that's the full content of the law, but furthermore, there might be other nuances that might have been missed. And you can further see this in one of the videos I created on Blackstone by John V. Orth as well, who sort of started the teaching of common law in the United Kingdom. Furthermore, there were practical reasons for incorporating legal formalism, such as the abolition of the forms of action on both sides of the Atlantic, caused which was a long-used framework, required these reclassification of many of these long-used frameworks, and jurists therefore looked for substantive principles and broader classifications of contract and tort. And therefore, in the third quarter of the 19th century, the first treatise on torts was published in Boston, written by Fransard Hilliard in 1859, and he evolved a series of principles far less fragmented and disconnected than found in the forms of action, and it shaped the ambition with jurists of the Gilded Age. So Michael Laubin is saying here is that there was a necessity of legal formalism because there were not strict rules, particularly in, for example, torts, as we see here, or in contracts as well. So the influences, he defines 3 primary influences here. First, that common law was forensic reasoning was becoming more popular, and therefore principles and doctrines outside the case, rationale desciendi, for example, Justice J.T. Coolidge, they began with principles as a guide because they were taking more, if they were looking at taking more forensic approaches to cases, they needed to have more, begin with these principles as a guide. Joel Bishop, who is considered a seminal classical legal scholar, supported these principles as evidence of the law and made of points that are practical rules that can be identified and enumerated, or principles, and therefore universally applying. So this is really the strongest interpretation of legal formalism, where there are these underlying principles that can be enumerated and taken in a very analytical approach. Very much different from a realist approach where they would be more flexible. A second cause, or second influence on legal formalism was, continuing on the first influence on the forensic reasoning, Holmes and Langdell, for example. In 1870, Holmes said, "It is the merit of the common law that it decides the case first and determines the principles afterwards." So he is a realist criticizing the legal formalists who set the principles before the case is determined. However, for Langdell, the principles after a series of chronological causes in casebooks. So the way the casebooks were written by Langdell, or not written by Langdell, but envisioned by Langdell would be that they are chronological and sort of lead to one direct conclusion. And therefore there was a commonplace belief in the 19th century that common law was growing and developing system where growth and flexibility potentially stunted by codification. So they wanted to keep it, or at least some people wanted to keep it flexible, but there needed to be a sort of doctrine or a counter-opposing force, such as legal formalism, to counterbalance this excessive flexibility while avoiding codification. So the second cause or second influence on legal formalism was Austinian jurisprudence, which was in his posthumously published lectures in 1863. They were aimed to analyze certain notions which meet us at every step as we travel through the science of law, and therefore there was an abstract, necessary notions, principles, and distinctions found in all advanced legal systems. So there's a common themes across different legal traditions. And therefore the analytical exercise of defining legal concepts and classifications was necessary, and a definition of law as a command. However, in Austin's definition, he defines law as the command of the sovereign, has been criticized, however, and he favored codification, but his ideas served as a toolkit following the abolition of the forms of action, and therefore it was of increasing importance. So despite Austin's having some criticism, like saying that law is the command of the sovereign, he still had a lot of merit or a lot of influence in directing people to have some sort of codification as to avoid overly excessive variability. And the third influence of legal formalism was given by the rival approach to historical jurisprudence, whereas Austin saw it as timeless and static. Sir Henry Maine's Ancient Law of 1861 stressed contingent and changing nature of law in progressive societies, and the social necessities are therefore more significant than the law itself. And therefore devices such as legal fictions, equity, and legislation cause law to keep up. So, for example, legal fiction, if you watch my video on Simon Stern, you'll see that legal fiction sometimes presupposes law itself. Furthermore, in Maine's work was widely read and traced the social changes from status to contract. So essentially this source here is that in Maine's work there's changes over time, and there was a legal formalism needed to sort of counterbalance this variability. Furthermore, Jering's attack on the begreris juris encouraged the abandonment of concepts of favor of the purposes of vision. But Maine did not wholly reject Austin's vision, and he endorsed it as a best conceptual apparatus with which to explain modern law. So although Maine did see it as moving, he saw benefit or merit in Austin's approach to doctrinalism. And therefore, both Laubin says that Maine and Austin could be seen as complementary works, whereas Austin leans on the side of codification or legal formalism, whereas Maine is more tracks social or political changes over time. Furthermore, legal formalism was also influenced by Savigny, who was a very key legal scholar who brought civil law to Germany, or Roman law more specifically to Germany, tracked the changing specialization in the spirit of the Volkgeist, which is the human spirit, which is a system des heutigen Romanisch Rechts, and therefore Savigny and the Pandectists, who were those who advocated for Roman law as well in Germany, provided a model for the mid-19th century, and which by uniting historical and analytical approach. So therefore this German approach combined perhaps both Maine and Austin, but nonetheless brought to the legal formalists in the United States the necessity of, or the demand for, sort of structure and formalism. Moving to part 3, later critics accused formalists of inhabitants of a very heavy use of legal concepts, and they and they were mocked by Rudolf van Jering and for being associated wholly with formalism, with Austinian analytical jurisprudence. Furthermore, Pound's phrase, new situations were always to be met with deductions from traditional fixed conceptions, but although he's being critical of that, he says that they should not be as fixed. So significant criticism towards legal formalism. However, the importance of analytical jurisprudence, as Austin notes, was best seen by scholars skeptical to Austin's work, according to Lobban, such as Frederick Pollock, who's in The Philosophy of the English or Analytical School is not mink. Nonetheless, it enraged or engaged in Austinian enterprise of classification. So even Frederick Pollock, who criticized legal formalism or criticized Austin, also even did follow his processes of classifications. And divisions made by lawyers were formal ways of reducing the world of human action to manageable items. So even the critics of legal formalism saw that there needed to be a little bit of legal formalism to reduce them to manageable items. For example, the duties owed to individuals in personam or to the world at large in rem. So some of these underlying principles of legal formalism, even by the realists, are agreed upon. Furthermore, Pollock also argued that comparative study could disclose typical conceptions of that are common to all legal systems. So this really a key underlying theme of legal formalism is that they're constant across legal systems as well. So if it's true on many legal systems, it's probably true generally. Holmes, however, was critical of Austin, and he argued any arrangement of laws had to be based on duties, not rights, as duties preceded rights both logically and chronologically, according to him. And he also, however, even despite his criticisms, he applied Austinian classifications to make law knowable. For example, he criticized Austin's definition of law as command of the sovereign, as previously mentioned. However, he agreed with him on international law and the duties of the sovereigns to the citizens. However, law was not entirely the cause of the force of the sovereign. And so therefore, in some ways, he improved upon Austin's ambition, but he ultimately abandoned it. So for Langdell, Holmes, Ames, and Bigelow all spent much time exploring the history of legal doctrines, so that's what makes it particularly relevant to this legal history, Oxford Handbook of Legal History, as the evolution of ideas from the medieval books onwards, such as the work of Maine tracks the history of law over time. However, he's not strictly a legal formalist, but nonetheless, these legal formalists followed these, because if there are these true doctrines, they should appear over time or throughout history. And they derive dogma from history. For example, Langdell's term of debt, he used a more ancient form from the assumpsit term, which was a more recent, as opposed to assumpsit, which was a more recent development. And Holmes furthermore dug deeper, but his conclusions and methods were similar to Langdell in this area. For example, the history of requirement of quid pro quo cases influenced both debt and assumpsit history, and therefore it was, although he did not consider himself a legal formalist, he was engaging in doctrinal work and also applying legal history. And he rejected logical will theory of contract, and he favored by the European jurists, including Savigny, as it was an endpoint rather than a starting point for future discussions. So once again, criticizing legal formalism. Ames, in Langdell's Age of Detriment, said Langdell's use of detriment lacked definition, and therefore applied a historical approach over a logical approach. So Ames is considered a legal formalist, but he thought that Langdell perhaps was too doctrinal and therefore applied more history. So history could be seen as, in some ways, a marginally opposing force to legal formalism, because there are multiple histories and things change over time. Why accept the former rather than the latter, or the latter rather than the former? So at least it opens for discussion. And above all, he considered the practical needs of modern society important, and perhaps Langdell was neglecting this in this discussion of the definition of debt. Furthermore, in terms of contracts, Maine saw as a terminus ad quem of development of modern society for a status to contract. So Maine is famous for saying that society has moved from status to contract. However, jurists at the end of the 19th century discussed largely settled topics, so they were changing some of these previously conceived notions, specifically contracts and torts. And Langdell, for example, he adopted a new concepts of contracts that were not definitively settled. So he went back to some of these concepts of contracts that were not definitively settled, and he did take into account policy consideration, or pardon me, he said policy considerations were irrelevant in the definitions of contracts, or for the common lawyer, and they could be settled with doctrinal reasoning. So therefore, formal or the general part versus the substantive questions, or the special part which dwelt with the kind of contractual agreements, should be maintained. So essentially, in contracts, there is a formal part, and then there's a general part, which is room for perhaps some realism or some social or political forms. But nonetheless, as we'll see, contracts were a place very ripe for legal formalism because they're very clear cut, whereas some areas are less so. And therefore, there was no coincidence the most logical common law treaties were to be found in the law of contract, for it was in this area of private law that jurists, whether Anglo-Saxon or continental, were most able to tease out rules in a largely abstract way. So contracts are more suitable, perhaps, for legal formalism than other areas that we might see. The law of torts, on the other hand, was in flux in the later 19th century, as it was much harder to find the elements of tort without considering which wrongs were to be redressed, unlike contracts. So there's a certain specificity of torts that contracts often does not have, and makes it a little bit more difficult to incorporate doctrinalism or legal formalism. Holmes chided Langdell's striving for elegantia juris, or logical integrity, in his summary, as in his own work he found common law of torts could not be defined in this way. So Holmes did write significant work on torts, but criticized Langdell's approach to make this logical integrity. He said, failed to see only from its formal side the ever adopting new principles on one side and old ones from history. There was a secret root, therefore, that was what Langdell was seeking for, a secret root, and the consideration of what is expedient versus the consideration of what is expedient to the community. So just by being expedient doesn't necessarily mean it's right as well. And therefore, it's traceable to public policy in its last analysis sometimes. So he's criticizing Langdell, saying that there is, even if they don't know it or don't believe it, policy implications of all decisions, or most, or many. First, he was the first main critic of formalism, that is Holmes, from arbitration, from his ambition to find general principles governing liability of torts, which was at the heart of private law at this time, and particularly treaties writers at the end of the 19th century. And because he said there was an infinite chain of causation in torts. So, in like a tort case, like a murder case, why did they murder? They had to get money, why did they have to get money, etc., etc. So it makes it more nuanced, it makes it more difficult to have legal formalism or legal doctrinalism. And he drew from the history of bailments, the yearbooks, and the assumpsit to what extent still survive. So he also derived from history too. So on both sides, both the legal formalists and the realists, like Holmes, did derive from history. And there was furthermore drew from, in his discussion, in his article Trespass and Negligence, said the principle of our law is that laws from accident must lie where it falls, and logic and therefore there's both logic and history components to it, and policy and consistency are also important as well. So on one hand consistency, but also on the other hand policy, and therefore the legal standard or the values of the community are often set by the jury. So although in Holmes's opinion, legal formalists may think sometimes they are implementing doctrine, but they may be neglecting some underlying needs of the community, especially, for example, in the case of the jury. The jury is not as in tune with doctrinalism. However, Langdell was more focused on contract doctrine, so it's where this is more natural. So maybe some of Holmes's criticisms towards Langdell were wrongly placed because contracts were actually ripe for doctrinalism. But Holmes nonetheless provided a model for other tort treatise writers. For example, Frederick Pollock in 1887 wrote, the purpose of this book is to show that there really is a law of torts, a time-living branch, not a collection of heterogeneous instances. So showing here that Pollock, who was also influenced by Langdell, and also, although he in some ways agreed with Holmes, he was also looking for something doctrinal in torts. And therefore, he was looking for, like Holmes, or unlike Holmes, an underlying theory. And so Holmes has stressed, therefore, policy as policy of the law and developed by jurists rather than the man of statistics or the master of economics. So he says that law is very different from statistics or economics, and it cannot just be solved fully logically, and therefore must take into account policy and policy of the law. And Pollock applied the practical account of lessons learned at Harvard Law School through both Langdell, and so therefore he was influenced by Langdell as well, but Pollock was more outwardly in agreement with Holmes. Daniel R. Erst, in The Critical Tradition of Writing American Legal History, published in 1993, he said, by the Yale Law Journal, Holmes lost faith in himself, in his coherent theory in the 1890s, but Pollock did not. So Holmes was at one point actually trying to find a coherent theory to torts, but eventually gave up, saying that there are these policy implications, whereas Pollock kind of stuck to almost a formalist argument, looking for constant legal formalism within the laws of torts. Therefore, Pollock's and maybe Holmes and others continued into the 19th century with struggles as well. So on both sides, both whether the realists or legal formalists, neither scholars could stick to one side. Some, like Holmes, even perhaps according to Daniel R. Erst, gave up or abandoned the objective of trying to find a singular law of torts, and therefore seized to or allowed for policy considerations and social and political pressures. So then moving to the conclusion, in chapter 5, he said, in one respect, the realist critique writers were correct. In the writers, in that they said writers in the Gilded Age did not see judges or jurists as subordinate legislators educated to resolve cases with policy considerations, instead through litigants. So, however, Gray says, if matters were not regarded as settled by authority, an army of judges would not suffice to keep society moving. So, firstly, he says the realists are correct that it is not entirely the jurists who determine the law. There's other underlying forces. But as for the legal formalists, did not think or concern, but the fact that legal formalists did not think or concern distinct categories, but they did not necessarily believe that it could be entirely legal formalism. So that is a correct notion, but I don't even think any of the legal formalists entirely believe that. And then to his final quote, he said, they saw the common law as a developing body, that is legal formalists, which served the needs of its community, but they sought to make better sense of it by using the latest tools offered by analytical and historical jurisprudence. So in aggregate, the legal formalists were trying to apply these new legal analytical tools incorporated by Langdell's study of case law. However, they also, in many cases, some more than others, did incorporate the opinions and needs of the community and political pressures. So, to discuss the slide, and then we'll move to the chapter by Noga, Morag-Levine. So, in terms of the institution, he was previously at the Queen Mary University of London School of Law, but he's now a professor at the London School of Economics, and he is a professor of legal history. The logos we have here are Cambridge University, where he received his Bachelor of Arts, University of the Witwatersrand, Witwatersrand in South Africa, where he received his first educational appointment, the University of Oxford, where he also had an appointment, the University of Durham in the top right, the Queen Mary University of London, and the London School of Economics. So many institutions he's been involved with, but primarily in the United Kingdom. However, he was born in South Africa. In terms of his research interests, it's history of the 18th and 19th century English law and lawyers. His specialization is in the relationship between doctrine, institutions, and legal and political thought. Suggested readings: Imperial Incarceration, Detention Without Trial in the Making of British Colonial Africa, published by the Cambridge University Press in 2021. White Man's Justice, South African Political Trials in Black Consciousness Era, published by the Oxford University Press in 1996. And The Common Law and English Jurisprudence, 1760 to 1850, published by the Oxford University Press in 1991. As for the quotes, formalism was in many ways defined by the anti-formalist critiques of the later generation of realist thinkers. So formalism itself was defined by the anti-formalists, realists. Next quote, the era of legal formalism is usually taken to refer to the period in American legal thought between the 1860s and the 1920s, when a new generation of post-bellum treatise writers and legal academics sought to discover the underlying principles of common law, cases, and put them into a rational order. Next quote, Langdell came to be seen as the intellectual progenitor of an entire tradition of scholars devoted to the taxonomy of legal concepts. Next quote, formalists saw the common law as a developing body which served the needs of its community, but they sought to make better sense of it by using the latest tools offered by analytical and historical jurisprudence. So, a very fascinating chapter, and it actually, I think, goes very well with the next chapter we'll be discussing by Noga, Morag-Levine, titled Sociological Jurisprudence and the Spirit of Common Law. In Section 3, Perspectives, Legal History in Modern Legal Thought, it is Chapter 24. Once again, Sociological Jurisprudence and the Spirit of the Common Law. So to briefly discuss her biography, she is a professor of law and the George Rummel Faculty Scholar at Michigan State University College of Law. She graduated cum laude from the Hebrew University of Jerusalem Faculty of Law, and received her PhD or her doctorate in jurisprudence and social policy at the University of California, Berkeley. She joined the Michigan State College of Law in 2004, and she was previously an assistant professor of political science at the University of Michigan and a visiting professor in the program on law and public affairs at the Princeton University, and she was a Lady Davis Fellow at the Hebrew University of Jerusalem. She currently teaches courses in environmental law and a first-year class on constitutional law and the regulatory state. In terms of her scholarship, she combines environmental regulation, legal history, and comparative law with a focus on influence of legal traditions and associated administrative implications, or associated administrative law as well. As well the principles on transnational differences in environmental and health law and safety regulation. And she considers this question across various periods in British and American history, as well as in contemporary environmental debates. Some of her books, her books includes Chasing the Wind, Regulating Air Pollution in the Common Law State, published by the Princeton University Press in 2003, and currently she's working on a new book. The working title, so this may change over time, is Pollution, Nuisance, and Precaution, Legal Tradition in Environmental History, and published to be determined. Some of her articles, not including this chapter, are Chemical Pollution and Regulatory Choices at the Start of Industrialization, Comparing France and Britain, published by the American Journal of Comparative Law. Actually, this one is still forthcoming. As well, one that has been produced is The History of Precaution, published by the American Journal of Comparative Law in 2014. So, significant work under her belt, and some articles as well. She's in the work of a new book and a new article as well, so very prolific and still very busy as well. So, to her chapter, Sociological Jurisprudence and the Spirit of the Common Law. So, she has an introduction where he said, first likes to thank Darrell Thompson for excellent editorial assistance in the preparation of the manuscript, and Malcolm Feely, Nicola Giocoli, Jonathan Levine, Chris Tomlins, who's one of the major editors, Christopher Tomlins, who's one of the main editors of the Oxford Handbook of Legal History, and perhaps they met when she was doing her doctoral studies at Berkeley, because Christopher Tomlins is a professor of law at University of California, Berkeley, as well, and the participants at the Tel Aviv University workshop for the comments on the chapter. So she thanks all those individuals as well. So she says, opens with this quote, "In the midst of constitutional tumults of the Lochner era from 1897 to 1937, Roscoe Pound published The Spirit of the Common Law and The Need for a Sociological Jurisprudence." That's two separate articles. In legal periodicals, The Green Bag, and they sum up key precepts that launched Pound's career in the decades preceding World War I and forged the lens through which early 20th century American legal history would come to be viewed going forward. So very, as we'll see, Roscoe Pound is one of the most significant legal scholars, certainly in America, but perhaps in the world, and particularly relevant in the area of sociological jurisprudence. So his article, The Spirit of Common Law, which is actually she includes in the title of her chapter, he says, both the start to the end were an ode to legal history favoring common law, and it was for its ability to adapt, and it was an individualism bulwark against modern collectivism. So Roscoe Pound's first mentioned article, and The Spirit of the Common Law, advocates in favor of common law. It covers history, and it also notes that common law is benefit to individualism and a bulwark against collectivism, or socialism as well. In his other article that she references, The Need for Sociological Jurisprudence, he calls for a new model of legal research, putting Blackstone and history aside, and has or a scientific apprehension of the relations of law to society and the needs, interests, and opinions of society today. So Roscoe Pound, advocates for a new form of legal jurisprudence called sociological jurisprudence that is not like Blackstone or is not like the legal formalists as previously discussed, but takes into account the needs, interests, and opinions of society today. Like most of Pound's writings during this period, these two articles manifest a tension and contradictions, particularly manifested such as old versus new. Three sociological jurisprudence are credited with there are three fundamental contributions to legal scholarship and American judicial politics. So, sociological jurisprudence, Morag-Levine credits with three major influences on American judicial politics, and sociological jurisprudence came from, as we might believe, Roscoe Pound. The first and most important influence was that it was a displacement of legal formalism and the attendant laissez-faire constitutionalism. So not only realism, but sociological jurisprudence also displaced legal formalism. So I think the best way of thinking of this visually is legal formalism and realism are two opposing forces, and sociological jurisprudence is kind of a third element which kind of addresses legal formalism and kind of helps it lead it in the direction of legal realism. The second influence of sociological jurisprudence is in part the product of the Brandeis Brief, which we'll discuss soon, in the transatlantic or the transformative potential of properly motivated courts and informed courts, and hence litigation as a tool for social change. So sociological jurisprudence demonstrates this or manifests this. And the third influence of sociological jurisprudence is that the understanding is transmitted from Pound to the legal realists, to the law and society scholars, of the gap between law in the books and law in action, and it therefore provided definitive research agenda fusing law and social science. So this third thing is that he heavily influenced the legal realists, who were perhaps the opposites of the legal formalists, and as well advocated for movement from the law in the books to law in the action through fusing law with the social sciences. So the actual contribution of sociological jurisprudence is subject to debate, starting with Pound saying it was the fashion of the time, and he himself said it was possible to overrate its value in 1921. So even the one who conceived sociological jurisprudence said it's possibly overrated. Carl Llewellyn had the same conclusion, however, for different reasons. In 1930, he said it remains bare of most that is significant in sociology, and one is embarrassed by the constant indeterminacy of the level of its discourse. So it has sociological jurisprudence in it. However, Carl Llewellyn says it lacks the most significant elements of sociology and doesn't really have a clear-cut definition. Others, they say the status was achieved despite or because of its meager content. And others, there are questions on the accuracy of the formalist narrative are superimposed, and therefore this might be considered the most important conclusion, is that it's perhaps going back to the previous chapter on legal formalism, perhaps the criticisms of legal formalisms were not formally grounded to begin with, so sociological jurisprudence as a concept is as a faulty base. Therefore, Morag-Levine says, in making better sense requires the understanding first of Pound's anxiety of future common law in America. So why did this come about, and his anxiety about the future of common law in America? And this was caused by the rising influence of continental legal administrative ideas during the era of growing transatlantic exchange. Furthermore, there was a threat of the German-educated social reformers and scientists bent on replicating continental legislation and administration models in the United States. So Pound's sociological jurisprudence, perhaps according to Morag-Levine, was, or perhaps most likely and probably true, is that it was because the growing influence of the German administration, particularly in the legal field as well. And inspired by Pound's social jurisprudence, he is explicitly inspired by Rudolf von Gering's biting criticism of the German historical school's jurisprudence conceptions. So within Germany, there were criticisms towards their system of administration, and Gering criticized it, and Roscoe Pound drew from Gering. Therefore, by contrast, this chapter finds differences between Gering and Pound's intellectual projects as an instructive in the meaning of sociological jurisprudence. So the crux here is that if Gering and Pound were the same, one could say Gering would have been the founder of sociological jurisprudence. But because they are different, that defines Pound as the founder of sociological jurisprudence, and therefore helps us better understand it, even though their ideas aligned in many ways. Gering saw law, or Roman law, as a force to end the struggle of self-serving interest, and it was devoid of a priori value. However, Pound saw common law put common law in admiration as a deep-seated historical custom. So, not directly contradicting each other here, but Jering saw issues with Roman law, but Pound sees benefits of common law. However, Pound did change his mind frequently, but not on this point. He always saw common law as the better system. And he saved law as an. Furthermore, probably the most important influence of Roscoe Pound is that he saved law as an academic discipline when law faculty budgets were wavering at the time, and this had the dual effect of lowering the barriers separating law from society and countering the alternative unified model, which is the Roman or German model in the academic systems, where law and society might have existed as a unified barrier-free field. So probably the most practical implications of Roscoe Pound, besides having influence on cases such as the Brandeis Brief, was that he reinvigorated the law schools and gave them their place by making it distinct from the other sociological sciences, but although incorporating the other sociological sciences, keeping them distinct, as we'll see, but also that he saw that it had to be it was running the risk of becoming a fully unified field, as in Germany they combine law with other fields. And as we saw in the chapter by Marcus D. Dubber, who's one of the editors of the chapter's civil law jurisdictions, their law schools are moving more towards interdisciplinarity, and common laws are moving towards doctrinalism, which is a very, very fascinating topic and a very fascinating video as well, I find. So moving to the next section, section 2, it's titled American Law and Politics in the Shadow of Germany. So what was this German influence on the United States that necessitated Pound's sociological jurisprudence? So it started with a trickle in the mid-1870s and to a flood in the 1980s. American students went to Germany for postgraduate education, and they brought back, usually studying economics, growing German favor of a unified German state and across the spectrum of the social political endeavors. So during this time, in increasing numbers, United States students were going to Germany to study, particularly economics, and they were incorporating, they brought back a growing German revolt against laissez-faire, and so therefore there was in Germany a more hands-on administration. Laissez-faire is leave to do. So therefore, a more hands-on administration they were bringing back to the United States, and also more interdisciplinarity. So that's the introduction to Part 2. So Section A of Part 2, Legal Science and Social Science. So in continental Europe, law was a pillar of the university education since Bologna, but under the auspices of, however, in common law, under the auspices of the English Inns of Court and apprenticeships with members of the bar, the legal education was more practical at first in both the US and the United Kingdom. So law schools were older in Germany. Harvard in 1816 introduced common law to the US universities as scientific and theoretical to show its value to the bar associations. So that's a driving force, as we saw behind Langdell's case method, is that it needed to be scientific to convince the bar of its value. In the German Pandectists, which is a word based on Justinian's Corpus Juris, which is based on Roman law, or is Roman law, Justinian's Corpus Juris, was more formal, systematic, and autonomous. But the legal institutions became more interdisciplinary, as we'll see. George Frederick Puchta was one of the most influential in this approach in the 18th century, or the second half of the 18th century, and the 18th century as a whole as well. And this process began in the 1870s with criticism of Pandectists, with Jering leading the charge. So in Germany, as we discussed many times previously, in Germany they have these Pandectists who advocated for Roman law, and then we have perhaps the Teutonic or the Germanic, which is more flexible perhaps. and Jering was criticizing the Pandectists. And he advocated for interessen jurisprudence, or jurisprudence of interests, and Burgessiff jurisprudence, which is jurisprudence of conceptions. And Jering first influenced the U.S. in his writings, in the writings of Oliver Wendell Holmes, who might be considered a realist, where he said, "The life of law must not be logic, it has been experience." So, considering the disadvantages of legal formalism as discussed, and therefore targeting Langdell. So, Jering influenced Holmes, criticized Langdell, because they needed to see law as accounting for experience, which would be a more Germanic or Teutonic, but not Pandectist. And he believed that a self-contained scientific enterprise distinct from Germany, Holmes in Boston University in 1897 said, "The path of the law is the present divorce between schools of political economy and law." So these two fields are separating, and he encouraged, however, every lawyer an understanding of economics, and blamed analogy, discrimination, and deduction for blinding lawyers to take side on debatable and often burning questions. So if it was too doctrinal, they ignored the relevant questions of the time, and that's something that Holmes advocated for, and something that Jering advocated for too, in criticizing Pandectism. So section B, so that was on legal science and social science. So legal science was distinct from social science, based on the Pandectist approach. Part B is German administration as a threat to legal hegemony and the common law. So as Morag-Levine notes, Alexis de Tocqueville famously noted, "American legal profession is dominated by U.S. public life." So two books I absolutely loved are Democracy in America and On the Old Regime and the French Revolution by Alexis de Tocqueville. Absolutely fascinating about the underlying forces of the United States and the French Revolution, respectively. But essentially one of the key takeaways, or one of the key, quotes by Tocqueville is that he says, in the United States, the public administration is largely controlled by lawyers. In Germany, however, the Staatswissenschaft, or is the primary degree leading to public life, and that translates to state science or political science, and it dominates public life, and it is a fusion of economics, statistics, and law. So whereas in the United States, where you have someone who goes to law school and then becomes a public servant, or in Germany they study political science or economics, law, and statistics, so it's more interdisciplinary, as we saw by Marcus D. Dover. And during the height of the German-U.S. university connection, it favored critiques of laissez-faire economics under the leadership of lately German historical, or later called the German Historical School, criticized laissez-faire. So because it was in law, it's the judicial side is separate, distinct from the executive or the legislative branches. In Germany, the legislative and executive branches are dominating because they already incorporate law, and they're sort of against laissez-faire or the German Historical School, or they're in favor of the German Historical School because that's their work there. The more laws they make, the better job they're on paper doing. Woodrow Wilson, one of my favorite presidents, although he's got some criticism, he has done some wrongs, but he has done many great things as well. He advocated to adopt scientific theories of German and French professors to solve issues at home. So there was a push by Woodrow Wilson. Woodrow Wilson, one of the reasons I do admire him is he envisioned the League of Nations, although he failed to have the United States fully create it, but nonetheless I think his vision created a much more unified world, so I think that's overall a positive influence. But nonetheless, he advocated for bringing German and French influences to the United States, so he was very much globalist. and he advocated for new forms of political science, and public administration became popular for climbing the public ladder. So public administration programs, I studied public administration, and it's very common, or it's frequent for those to study public administration to be in the public service, and they became popular and under the inspiration of Woodrow Wilson. For example, it was formerly called the School of Public and International Affairs at SPIA at Princeton University was formerly called the Woodrow Wilson School, but it's not, as we know. Princeton, or as many know, Princeton does not have a law school, so very much in Wilson's legacy. In Thomas Cooley's writing to Justice Field's dissent in the Slaughterhouse Cases and Christopher Tiedeman's treatise on police power, read the Constitution to give veto power over legislative interventions, and therefore it was a continental-inspired progressives advocated administrative law as comparable with the Constitution. So some jurists saw that the laws created by governments were equal to the Constitution, but this was perhaps a threat to the United States judicial hegemony, because if the Constitution is just as equal to other laws, then that really weakens the judicial branch. In 1898, Holden v. Hardy, there was a win for the presumptive constitutionality of social legislation, where this is a case discussing a limitation on hours, minimum or maximum working hours for minors, and this was a win for presumptive constitutionality of social legislation, in that it was permitted, or the laws that said that there was maximum working hours was turned down because it was against the Constitution. In 1905, in Lochner v. York, that was a win for the legislation because they put the laws in favor of the Constitution. However, in 1905, in Lochner v. New York, they turned things around, and this built up anger as it advocated for controlling the judiciary, including the recalls and constitutional amendments, and to curtail judicial review. So Lochner v. New York was, we'll discuss shortly as well. This, unlike Holden v. Hardy, put weakened the Constitution, and therefore the U.S. Supreme Court ruled that New York State's laws setting maximum workers' hours for bakers, so it was the limitation on the hours from bakers, violated the freedom of contract under the 14th Amendment. But Holmes, as we see, is a major realist, dissented, saying that this is just a laissez-faire implication, and he provided historical examples as well. So these cases are very important. It's like the question is, to what extent do the governments have power to make laws that contradict with the 14th Amendment? And in Lochner v. New York, the Constitution won and turned down the law, saying that it could not. But Roscoe Pound says it's just perhaps a political move to minimize government intervention. Therefore, they first attempted. So then, moving to the third section, Roscoe Pound and the Sociological Jurisprudence. They first attempted systematic analysis of the meaning of and reasons behind the legal crisis in the speech by the American Bar Association. So he was the one to really say this is like a crisis, that there's not enough social forces, and it's becoming too doctrinal. And he said the causes of the popular dissatisfaction with administration of justice in 1906. He said dissatisfaction with administration of justice is as old as the law, and the cause was the powerful challenge to the common law doctrine. So that's opposing legal formalism, one might say. And he might However, in the title, Morag-Levine notes that it might substitute judicial review or supremacy of law for the more antiseptic administration of justice. So it's not that administration of justice is wholly bad, but too much judicial review or too much supremacy of the law was seen as a risk by Roscoe Pound, and it potentially prevented growth as well. The courts distrusted, and executive powers were given plenary powers, and it was a continental-style institutions of administration of law. And therefore he looked to German social theories of law as a means to regain trust, and therefore introduced sociological jurisprudence as an antidote for this, the judiciary becoming too strong. So part A of this section, sociological jurisprudence and the law schools. So Pound launched a sociological jurisprudence as Dean of the University of Nebraska College of Law, where he actually did his undergraduate degree studying botany there from 1903 to 1907. He received also his, he was the Dean of University of Nebraska College of Law from 1903 to 1907, but he received his Bachelor of Arts and Masters of Arts in 1888 and 1889, respectively, in botany. So a little bit of background about him. He's a botanist by his previous field of study. He also, at the time, the University of Nebraska College of Law was a new one, and it was considered a stepchild, and was only made part of the whole university in 1891, so only 2 years after he received his master's. And the university formally focused on agriculture and natural sciences, and useful arts. So it was not the hottest place at the university at the time he was dean, or even up until the time he was dean. And he was concerned about the financial resources of the College of Law and seemingly inferior status in the land-grant institution. Therefore, he devoted himself to updating the curriculum and moved away from dogmatic instruction of the large and older schools, meaning Harvard. So he wanted to move away from this legal formalism that was common at the older schools, such as Harvard, introduced by Langdell, and therefore advocated for what's called collateral studies, such as history of law, jurisprudence, philosophy, and Roman law. So even though there are issues with Roman law, he still advocated for learning about it. So to protect the role as a legislator, he thought there was a threat to the social sciences, and therefore he didn't want to entirely threaten the social sciences, or exclude policy sciences, but absent in his speech was an attempt to link the legal curriculum reform with the surrounding political and legal crisis. So although he had formally, he later spoke out against this crisis, and his original time as Dean of the University of Nebraska, in his original speech, he actually did not say he was doing this to address the crisis, although he might have been thinking it, or maybe he hadn't fully realized what he was doing yet. But later in 1905, while still Dean at the Columbia Law Review, he said, "Do we need a philosophy of the law?" He began, and he said the source of the problem of excessive individualism is, this will address that, and they need a more even balance with socialism. So it's interesting because now, post-Cold War, advocating for socialism is generally not very positive, but at the time they needed this, particularly with the very doctrinal legal profession. Therefore, his solution was not to recall judges or pack the courts, but a more balanced education. And therefore, social and political science, he said, are social and political science not necessary? Unlike Holmes, however, in his path of the law, it was not separate social science courses, but concrete legal problems. So it's not that students in law school should take full social science courses, but implement them in their legal problems by looking at actual decisions with a social science lens. Therefore, legal doctrine remained concrete pillar of education, and not get too mixed in as they have in Germany. and therefore it permitted it to receive more academic funding and remain a hegemony in legislation and politics. So he wanted to keep it distinct, although implementing or including political and social sciences. In 1910, he famously said research agenda was a link to law in the books with law in action. So by doing this, it would make it more applicable, perhaps. Christopher Tomlin says this was a message only lawyers could do, one of the editors of the Oxford Handbook of Legal History. And later, it's important to note, Roscoe Pound became the dean of Harvard Law School from 1916 to 1936, and he actually only studied at Harvard Law School for 1 year and never graduated, but he became dean nonetheless, likely from his large plethora of writing, of articles, and his success as dean of the University of Nebraska College of Law. Part B of Section 3, Jering, Pound, and Legal History. Pound's 1905 article, The Spirit of Common Law, also gestured Jering's The Spirit of Roman Law through the stages of its development by using perhaps the word spirit, but I also think it might note, perhaps I actually have it here, this book, The Spirit of Laws by Montesquieu, so although the author here says that likely Pound was influenced by Jering's writing, they were probably both influenced by The Spirit of Law by Montesquieu. But nonetheless, he advocated for a decoupling of Roman and other law, or der Gist, and Jering advocated against Pocta and the Pandectists. He saying the times of Ulpian and the Paulas are gone forever. Those are two famous Roman legal legislators. And he also, in Pound's writing, echoed Jering in a priori commitment to rights of individualism, but advocated for hold even more balance versus a relic of the past, or obstinate conservatism. So advocated for more individualism as well, but not too much conservatism as well. So needed a balance, and they both saw this. And he was more ambivalent to Jering's later works in positivist and his instrumentalist legal theories, such as in The Struggle for Law, published in 1872, and Law as a Means to an End, where he said the origin of law was from the ability of the powerful to monopolize force on behalf of selfish interests. So that is something that Jering believed, that it was the ability of the sovereign likely to monopolize force. However, Pound believed it was prerogative of Jering believed it was the prerogative of the state to determine which interests deserve protection, and therefore it was a means to end, or the final end to the existence of society. So, however, Pound saw it differently as the culmination of the needs of society. So although they agreed in many ways, or at least they agreed in that which they disagreed on, which is the over individualism or laissez-faire, or the doctrinalism in the United States as well, they disagreed on where law comes from, whereas Jering saw it as more of a top-down approach, whereas I would say Pound saw it as more of a bottom-up approach. Pound in Law in the Books and Law in Action said history of justice juristic thought tells us nothing unless we know the social forces behind it. Elsewhere in The Scope and Purpose of Sociological Jurisprudence, published in 1912, he said Jering ignores important element of contemporary law, that legal history shows clearly ideals of justice and morals controlling factors in all periods of growth. So advocating for a bottom-up approach. Abdication of law in favor of administration as well, and the danger lurking from equating law with the welfare of the state, so not too much administration as well, which is a risk that Jering might allow for. However, Jering's enduring value for sociological jurisprudence was the debunking of the formalist methodology of conceptual jurisprudence and the lessons of the deficiencies of laissez-faire courts. So they both, or Jering's contribution to Pound was the debunking of the formalist methodology and the deficiencies of laissez-faire courts. So as I said, they agreed on what they disagreed on, but they didn't necessarily agree on what they believed in. For Jering, jurists or lawyers kept in touch with life was necessary, but for Jering, law is a means to social ends. However, for Pound, common law is an end in itself, according to Morag-Levine. So, moving to section 3, the last section before the conclusion, it's almost there. So Pound built on Holmes's foundation. Section 3 is called Sociological Jurisprudence and the Invention of Formalism. So Pound built on Holmes's foundation, opposing sociological jurisprudence as antithetical to formalism. But the most important, though unintended, contribution of the manifestation of the Lochner dissent, where the general propositions do not decide concrete cases. The decision will depend on judgment or intuition more subtle than any articulate major premise. This was a legendary dissent in the Lochner case, as we'll discuss in more detail right now. The majority were guilty of Langdell's, in this case, according to Pound, were guilty of Langdell's supposed error. This is Holmes's criticism, and their blind belief in logic, and therefore more important than the judicial institutions and other elements of social experience. So Holmes criticized this case, this Lochner case, and Pound learned much from it. And the Constitution was not meant to embody a specific economic theory, such as laissez-faire, which is Holmes's criticism. So that was the Lochner case, the maximum hours for bakers. Basically, the Supreme Court turned down New York's law, saying that the 14th Amendment prevented for such implications. And Roscoe Pound, said that it was a way of implementing laissez-faire economics, so it did have sociological meaning behind it. Less than 3 years later, however, in Muller v. Organ, often called the Brandeis Brief, the Supreme Court upheld a decision limiting work hours for women in the laundry industry. According to the National Consumers League, submitted socio-medical evidence, which is non-medical evidence, or both, however, showing the risks. Perhaps the Lochner approach was too logical, whereas in the Brandeis Brief they incorporated more social factors, and it was perhaps the Lochner case was too formalistically insulated. However, the Brandeis Brief turned the story around on its head in 1908, less than 3 years later. So in Pound's article Mechanical Jurisprudence, published in 1905, before the Brandeis Brief, he said the 14th Amendment conception of freedom of contract made on the basis of logical deductions was and had a flurry of criticisms of the Lochner case, so saying it's based on laissez-faire, such, and Holmes disagreed with it as well. But nonetheless, in this new case, in the Brandeis Brief, there seemed to be a win for sociological jurisprudence. The Brandeis Brief can be seen as the first example applied of sociological jurisprudence in action, and it manifested law in the books, coming into law in action, according to Pound in 1912, with the data from the social sciences. And Louis Brandeis in 1916, which the Brandeis Brief is named, said to the Chicago Bar Association that they did not displace lawyer, but to fit him for more official or judicial tasks. So something that Roscoe Pound was already working on was later determined in the Brandeis Brief or the Muller v. Organ case, and later writings of Louis Brandeis. And it was not until the end of the century formalist theory became at serious doubt, however, so the formalist theory was still popular. And when foreign critics blamed it for at the time blamed the humble state of the legislator in common law America, and not the formalist theory. In Germany, formalism or legal science was linked to laissez-faire and the creation of private law, and it was free from public law institutions, and grew in spite of socialism. So there was a lot of socialism growing in Eastern Europe, but Germany was becoming, perhaps we might call it more right-wing. And anti-formalism, or anti-Pacta, who was a leading formalist or doctrinal thinker, Pangdectist in Germany. And it became, one might say that sociological jurisprudence became the instrument of legal liberalism, particularly in the United States, but also as a force in Germany as well. So it kind of retroactively affected the other country, but Germany kind of already has that sociological jurisprudence built in because they study state science anyways, so they don't not have a really distinct law schools as they have in the United States. So it's an entirely different system, and advocating for more sociological jurisprudence might be too much. So let's move to the conclusion, and we'll discuss the slide and the comparison. So Pound, borrowing from the contemporary German legal theory, particularly Jering, but not drawing from those such as Pacta, turned the early 20th century to a new creed of sociological jurisprudence as an antidote to transatlantic threats to long-term survival of common law. Because at the time, law schools were not doing too well, and people were starting to study more public administration or other social sciences before becoming politicians. And social science was an alternative to civil law, and it was affiliated with the administrative paradigm and threatened law schools and professional concerns of the bar and the core constitutional principles of judicial supremacy in the United States. So there's this underlying need for Pound in the United States, and I think the same would also apply to Canada as well, and perhaps the United Kingdom as well, to most common law countries, in fact. And therefore it was becoming more empirical, fact-sensitive approach was needed, and that so that brought legal formalism, but then Pound outlined the precepts in a long list of articles and planned book to bring sociological jurisprudence. So I think both legal formalism and sociological jurisprudence were kind of necessary developments in common law jurisdictions, the latter coming from the influences of continental Europe. They later, however, Pound somewhat abandoned it in the spirit of common law, and he revived only cursory or ultimately skeptical treatment of sociological jurisprudence, because he worried in the hands of growing realist movement that it might strengthen the administrative state. So it might become, it might be used to strengthen the administrative state. So it has its risks as well, but it was a lifeline, and also a risk as well. Therefore, such as the Law and Society, an important organization, has been influenced by Roscoe Pound, and he also survives in the realist legal tradition, even though he became skeptical of particularly legal realism in the latter years of his life. He really did influence or get it going through, including sociological jurisprudence in law school curriculums at the University of Nebraska and Harvard Law School. So for many, now there are many law and, like for example, law and society, law and film, for example, courses, and the spending for law schools has increased additionally, and there are also more empirical, social, and scientific perspectives included in law school curriculums, so they've all since changed through Roscoe's influence on sociological jurisprudence. And the impact on the Lochner era, for example, Brandeis' brief may be considered to be through the influence of Roscoe Pound's writings on the Lochner era after his being upset with the findings of the Lochner case. And Pound understood the conflicts this conflict was at the root of the civil law common law divide. So that is a very important contribution of Roscoe Pound in this area. And the ease of the formalists in the Lochner court is a warning, Morag-Levine says, in that sociological jurisprudence seemingly affects legal historians one more lesson on the ways in which historical narratives are consonant with the values of legal elites are liable to gain purchased fact or no fact. So essentially, even if there isn't one such as Roscoe Pound to point out the sociological influences, they're still there, such as in the Lochner case, where it might be seen the laissez-faire ideology was the deciding factor behind the finding of the case. So that is the conclusion. I hope you found that fascinating, and I hope you were able to watch two videos, the two chapters side by side, because I think legal formalism and sociological jurisprudence. The next chapter will actually be legal realism. So I said legal realism and legal formalism are sort of contrasting forces, but sociological jurisprudence is a way to perhaps upgrade legal formalism to make it to address some of the issues it has. So I'll talk about the slide, and then we'll discuss the comparison. So she's at the she's at institution Michigan State University School of Law, and she is a professor of legal history. In terms of the images, we have here the Hebrew University of Jerusalem, where she first studied, University of California, Berkeley, where she received her PhD, and the University of Michigan, where she had an appointment, and the University of Princeton University, where she had an appointment, and Michigan State University College of Law, where she is currently a professor. And pardon me, she is not the Hesley yet a professor of law. That was from the previous slide. I didn't update that. She's a professor of legal history. Her area, and also a professor of environmental law as well. Her areas of interest include environmental regulation, legal history, comparative law, legal traditions, and administrative law. Her courses include environmental law, and as well as the first year constitutional law and regulatory state. So black letter law course, it's called. Those are the first year courses that are, as opposed to non-black letter courses such as law and, which are more auxiliary and more aligned the lines of sociological jurisprudence. Her suggested readings are Chasing the Wind, Regulating Air Pollution in the Common Law State, published by the Princeton University Press in 2003. Chemical Pollution and Regulatory Choices at the Start of Industrialization, Comparing France and Britain, published by the American Journal of Comparative Law, which is forthcoming. Book, and Pollution, Nuisance, and Precaution, Legal Traditions in Environmental History, which is a working title, so be warned if the title changes by the time you hopefully buy the book, and that is forthcoming as well, to be determined. As for the quotes, making better sense of sociological jurisprudence requires, at the start, greater emphasis on the source and meaning of Pound's anxiety over the future of common law in America, the rising influence of continental legal and administrative ideas during an era of growing transatlantic exchange. Next quote. Borrowing from contemporary German legal theory, Pound turned in the early 20th century to the new creed of sociological jurisprudence as an antidote to transatlantic-inspired threats to the long-term survival of common law. And last quote, sociological jurisprudence seemingly offers legal historians one more lesson on the ways in which historical narratives that are consonant with the values of legal elites are liable to gain purchase, facts or no facts. So that is the chapter and biography of Noga Morag-Levine. To the comparison in the style of Plutarch's Lives to hopefully reveal a little bit more about these two scholars and their two respective chapters. So, to start, Michael Lobban is from South Africa, whereas Noga Morag-Levine is from Israel, or at least that's where they both, or at least that's where she did her undergraduate degree, so I believe that's likely where she was born as well. However, similarity is that they both are now professors in different countries from that which they were born, where the former is now a professor in the United Kingdom, and the latter is now a professor in the United States. So although both of them have no overlapping countries in their academic careers, they both have the commonality in moving. They both have a doctorate, so some legal professors don't have a Doctor of Law, however it's most common that they do, or a doctorate generally. However, Michael Lobban's doctorate was at Cambridge, and Morag-Levine, Noga Morag-Levine, professor, received her doctorate from UC Berkeley, University of California, Berkeley, so both great institutions. They, on the one hand, Michael Lobban taught in South Africa, however, so he went back and taught in his country of birth. However, Noga Morag-Levine has not actually taught in Israel. However, she actually did study in Israel, whereas Michael Laubin did all of his studies in the United Kingdom. They're both largely academics. I have not seen too much information if they've had practice, but so they're both largely pretty focused academics. Their two chapters differ quite significantly, whereas one discusses legal formalism, which is kind of one side end of the spectrum, whereas the other is sociological jurisprudence, which could be seen as definitely an opposing force or an antidote for legal formalism, but I think the exact opposite of legal formalism would be realism. However, both a common theme of both of their chapters is they both do discuss legal realism, so they're both aware of all these forces. Another small thing, one is a man, one's a woman. That is just something to note, but obviously that has very many different life experiences and implications. Michael Lobban has written 3 books. Noga Morag-Levine has written 1 book, however she is still in the process of writing another book, so they're both prolific writers. However, Michael Laubin has more. He has also been a scholar for longer as well. So they're both, I think, important to note. And I titled this series Legal History and Historians because I take a people approach. I do these biographies as well and comparisons. I think it's important to note that these two had a very much biographical way of writing, whereas the former, Michael Laubin, wrote significantly about Langdell and his influence as Dean of Harvard, and Morag-Levine wrote significantly on Pound and as Dean of University of Nebraska and later on at Harvard Law School. And they both discuss Holmes quite extensively because his influence on realism. They both discuss common law, coming from common law. However, they both have a significant awareness of civil law influence. However, I think Noga Morag-Levine notes more the influence of the Germans or the continental Europe, particularly Germans' influence on sociological jurisprudence, whereas the causes of legal formalism was more self-contained. So that's not that perhaps Michael Laubin is less interested in civil law. His just area of practice just didn't come up as much in the chapter. So as noted, they're both legal history and historians. They're both a little bit, although they know much about the legal formalism and sociological jurisprudence respectively, they do both note that some skepticism towards the two. I think too much of either is important. However, I think they're both important as well, and I think they know that and believe that as well. Otherwise, they would not make it a critical piece of their scholarship if they thought it was altogether bad. But I think bad things need to be studied just as much as good things. In terms of auxiliary things, they both, besides their interests in legal formalism and sociological jurisprudence, respectively, Michael Laubin also does significant work on racism, incarceration, and imperialism, whereas Noga Morag-Levine has significant work on environmental law. So different areas that supplement the 2 respective areas that we discussed in these 2 chapters. So, thank you so much for watching this. I hope you enjoyed it as much as I did. I thought these were 2 very fascinating sections and scholars, and I learned a lot more about the spectrum of legal academia, and legal history as well. So, thank you so much for watching, and I hope you continue to support.